Hello, everyone, and welcome to our webinar on what you need to know about responding to third-party subpoenas. I'm Sarah Zimmerman. I'm an attorney in Husch Blackwell's Healthcare, Life Sciences, and Education group. I partner primarily, but not exclusively, with healthcare companies to resolve complex litigation, represent clients facing contract disputes, business torts, TCPA claims, and antitrust actions. And I also have a lot of experience handling third-party subpoena responses on behalf of an array of entities in a variety of types of litigation. Joining me today is Amanda Bogle. Amanda, I think you might still be on mute.
You are.
Everyone, I think Amanda might be having some issues with her audio. Amanda is an attorney. Amanda, do you want to try that again?
Can you hear me now?
Yes.
Oh,
sorry, everyone.
Got it. We were just talking about this before. My audio has been giving me some trouble lately. Okay. I am also an attorney in Husch Blackwell's Healthcare, Life Sciences, and Education group, but my specialty is in healthcare regulatory and transactional work. I do deal a lot in the HIPAA space as well, which I will primarily be covering during this presentation.
Thanks, Amanda. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for use during the program today. If you have any questions during the webcast, please submit via the question box, and we'll try to answer all questions during the webcast today, either while we're presenting or at the end if time is allowed. But if a fuller answer is needed or we run out of time, it'll be answered later via email. Additionally, a PDF of the presentation is available in the Program Materials folder. This program has also been approved for legal education hours. For live attendees, report your hours by clicking on the CEU icon at the bottom of your screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. And that's all the housekeeping items I have for today. So let's talk about subpoenas. This is a brief agenda of what we plan to cover today. We're going to discuss the basics of third-party subpoenas, and then we're going to talk through how you respond to a subpoena, starting from the time you receive it through to the end of the matter. So let's start with the basics of what is a third-party subpoena. Many of you, I'm sure, are familiar with the concept of litigation. An entity or individual sues another based on their claims and the defenses. The parties are entitled to discovery or obtaining evidence from the other parties in the case. In federal court, that's covered under the standard of Rule 26, which provides that the scope of discovery is non-privileged information relevant to any party's claims or defenses, proportional to the needs of the case. In ongoing litigation, the federal rules have specific mechanisms for getting this evidence or discovery from the parties to the case. I'm sure you're familiar with requests for production or requests for admission, interrogatories, depositions. A third-party subpoena is the mechanism that specifically enables a party to seek testimony or documents from a non-party individual or entity. As I already mentioned, Rule 26 today, we're going to focus on the federal rules because it has the broadest applicability to the group here. But we will sometimes comment on specific state issues where it may require additional research or a slightly different approach if you're looking at a subpoena that was issued out of state court. So in federal court, third-party subpoenas are governed by Rule 45. Rule 45 has 7 sections. We're not going to read them here together today, but I'd like to outline a few of the details that you'll see outlined specifically in the rule. Let's start with Section A. that really talks mostly about the form of the subpoena and what is required by the party who is issuing the subpoena. It requires every subpoena to state the court from which it's issued, provide the title of the action and the case number, provide a specified time and place for compliance where a person is expected to provide documents or appear for a hearing or deposition testimony. And it's also supposed to provide the text of Rules 45, Sections D and E, which discuss protections for third parties as well as responding to the subpoena. I actually had an instance once where our client received a subpoena that did not include the text of those rules. Now, a court is not going to void a subpoena because it didn't necessarily follow that format. However, it did buy us some more time in responding to the subpoena while they sent us a corrected version. For the most part, though, Section A is very easy to comply with. As you can see the form on the slide, most district courts on their website will have this form and you can fill it out, and it usually will comply with these requirements. I'm not going to discuss Section B now, which covers service, as we'll get to that in a later slide, similar to Sections D and E. But I do want to touch on Section C, which creates geographical limitations to a subpoena. It limits a place of compliance for the subpoena to 100 miles. What that means is for a deposition, appearance at trial, or appearance at a hearing, a third party can only be commanded to appear within 100 miles of where the person resides, is employed, or regularly transacts business. For documents, that 100-mile rule likewise applies. You're only commanded to provide documents within a 100-mile radius of where the person resides, is employed, or regularly transacts business. In the world of the internet and email, this document place of compliance is a little bit more fuzzy. In most instances, you will be providing your production via email or some type of secure electronic transfer. This is not the same as the days when you had to print out all of your documents and provide hard copies by actually mailing them to someone's office or delivering them in person to an attorney on the case. That said, this place of compliance is still very important, and it's important to note when the issuing party gets it wrong. That's because the place of compliance is what dictates which court would hear any motions on a subpoena. So if you're a Missouri resident and your company is based here and your records custodian is located here, that is the court that should hear the motion. So people get this wrong a lot. We see a lot of subpoenas where counsel will put their own address. They will put a location that's in the area of where the case is pending. And that's not appropriate where, for example, your custodian of records is located in St. Louis, but they put a place of compliance that is in California. Our usual practice is to point this out to the issuing counsel when we send them our objections and let them know that we consider the place of compliance and therefore the subpoena void. However, in most instances, we will continue to work with the issuing party on responding to the subpoena. Where this really comes to be an issue is if you are getting to motions and making sure that the any motion to quash, any motion to compel is filed in the right district. With all of that being said, Section F provides specifically for the ability to transfer those motions, despite where the place of compliance dictates the motion must be filed. Section F requires that where the a court may transfer, it's a permissive standard, may transfer a motion under this rule to the issuing court if the person subject to the subpoena consents or finds exceptional circumstance. And while that sounds like a high standard, we have certainly found that courts may want to get this motion off their hands and send it back to the court hearing the remainder of discovery issues in the case. That said, we have also had experience where courts have wanted to keep the motion and protect the residents of their district. Finally, I'd like to point out Section G, which provides that a court may hold someone in contempt if they have been served with a subpoena and fail to obey the subpoena or an order related to it. I point this out just to make sure that no one is ignoring any subpoenas they receive. So once you receive the subpoena and you've had a chance to look it over and make sure it complies with all these rules and give it an initial review, you're going to want to confirm that proper service and jurisdiction. Let's start with service. Rule 45B requires delivering a copy to the named person. This has been required a little bit differently in different circuits. Some will say that this requires personal service. Others may not require personal service, but service reasonably calculated to ensure receipt. For example, in the Eighth Circuit, they've looked at this standard as requiring more than regular mail or fax, but usually find that certified mail is appropriately calculated to ensure that a party is receiving a copy of the subpoena. You're going to want to double check the case law in your jurisdiction before determining that service was appropriate. Likewise, if you receive a state court subpoena, you're going to want to double check the state rules to ensure that service was proper. All of that said, usually if your registered agent is served, that's a pretty good sign that you were reasonably calculated to ensure receipt and you have notice of the subpoena. Looking to jurisdictional defenses, I'd like to briefly touch on this because this has been an excellent avenue, especially when receiving a state court subpoena, for potentially arguing that the subpoena is unenforceable. That said, this is kind of going by the wayside. More and more states, I believe it's 47 states and the District of Columbia, have now joined the Uniform Interstate Depositions and Discovery Act. The UIDDA standardized the process for issuing third-party subpoenas across state lines, meaning that it's much easier to enforce a subpoena on a non-party, non-resident when a case is pending in a different state court. But historically, what this has meant is, for example, you have a case pending in the state court in New Mexico. The parties are seeking third-party discovery and want to issue a subpoena to a Missouri company. That New Mexico court doesn't have jurisdiction over that Missouri resident company. They cannot compel them to provide documents in New Mexico. So what will have to happen is the New Mexico counsel would get local counsel in Missouri. They would open a miscellaneous matter in Missouri and have the Missouri court issue that subpoena to the Missouri resident. That is also then the same court that would hear any motions on that subpoena. This is a process called domesticating a subpoena. And like I said, it's largely going by the wayside. I do believe Missouri and Texas are continued holdouts to the UIDDA, but they do keep threatening to enact legislation that enacts the UIDDA in their states. So it's something to keep apprised of as the law continues to change. I also want to note that if you receive a subpoena that is issued by an arbitrator in arbitration, whether AAA or some other program, there is good law to support that arbitrators do not have the authority to issue subpoenas for basically pretrial discovery, to appear at depositions or the authority to provide documents during a pre-hearing discovery context. They do have the power to compel a non-party to appear at a hearing, but that is a pretty limited authority under the FAA. So based on the subpoena you receive, if it's in state court or through an arbitration, you'll want to keep an eye out for these potential jurisdictional defenses before you respond, and make sure that you're clear on the law and application to you and your client. As I said, our typical practice here is to raise these issues before objections are due, or potentially in our objection letter to the issuing party. Keep in mind that this is different than a personal jurisdiction argument, which is what a lot of parties will say in response to raising these claims. But these concerns should be evaluated differently because it's really about the jurisdiction a state court has over a non-party, non-resident. Once you've confirmed service and jurisdiction, you should consider whether you need to issue a legal hold. I'm sure many of you are familiar with this concept, but just to briefly discuss what a legal hold is, it's a memo or similar document that is issued to key custodians, key employees in your company that prevent them from deleting relevant documents to a case. It usually includes all kinds of information about how to make sure that documents are retained, what is considered a relevant document, and some other types of key pieces of information. This is to avoid any issues of spoliation. We're not going to talk in detail about what a legal hold looks like and what is required. That could be the subject of an entirely different CLE. But I do want to mention that we do at Hush have examples of legal holds. And if you have additional questions about what might need to be contained in a legal hold and whether one is required, please don't hesitate to reach out. What I do want to cover in the context of responding to a third-party subpoena is when the duty to issue a legal hold arises. And that duty to preserve evidence arises when a party reasonably anticipates litigation. So that means a subpoena does not automatically trigger a duty to issue a legal hold. It's a matter of really understanding what the subpoena is targeting, what the case is about, which we'll discuss a little bit here in a minute in more detail. But you need to understand, do you think that there is a reason to believe there might be liability? Is someone accusing you of doing something wrong and the subpoena has triggered your notice of that dispute? I can give an instance of a subpoena where we did decide to issue a legal hold. And that was a case where we represented a pharmacy who received a subpoena in a dispute between two drug manufacturers. While usually that might not trigger the need to issue a legal hold, in this case, it turned out that the pharmacy was an exclusive distributor of the product that was at issue in the case. That meant they were going to have a lot of documents that were going to be more relevant to the litigation. There were some potential allegations that the pharmacy may or may not have done the right thing. And so this was an instance where we felt it was important to make sure that relevant documents were preserved. And we didn't get into an issue where we were accused of spoliating documents in the future. Tying into this idea of whether you need to issue a legal hold in response to a subpoena is really understanding the scope and context of the subpoena and the litigation at issue. So what this means is when you are preparing to respond to a subpoena, it can be pivotal to understand the case, the allegations, and your relationship to the parties and the claims at issue. Our recommended practice is to first review the complaint once you receive the subpoena and have taken a look. Once you take a look at the operative complaint, maybe any counterclaims, answer and affirmative defenses, if there's been motions to dismiss or any orders, all of those documents will have key pieces of information that will clue you into what this case is about, what are the parties arguing about, and then you can get an understanding of how do you fit in? What is your relationship to the subject matter at issue? Are you mentioned in the complaint? Are you alluded to? In what way? Is there potential liability that might trigger duties to preserve documents and issue a legal hold like we were just discussing? All of this might change the posture of your response. Do you have leverage in providing documents quickly to assuage any concerns that you did anything wrong? Or do you want to push back more because you are very involved and you expect that they're going to want a lot of information from you and you need to take a strong stance from the beginning? Also, reviewing the complaint will clue you into the relevant time period of the case. It's important to see what the allegations are in the complaint and what time period they cover, and how does that compare to what's being asked of you in the subpoena? Do they match? Are they different? It will also allow you to be wary of a fishing expedition. Are the subpoena requests directed to you very different than what the claims are in the case? Is it clear that they are trying to see if they can bring an additional claim against you that hasn't already been pled and therefore is not relevant discovery under the Rule 26 standard? In addition to just reviewing the complaint for the allegations and the claims in the case, the causes of action, it's important to take a look at who the parties are to the litigation. What is their relationship to you? Do you have a business relationship with these parties? Are they key competitors? It helps you understand exactly how you might fit into this puzzle. And it can frame how you're going to respond to the subpoena. I have another example where we worked with a client who was responding to a subpoena that was issued by one of their main suppliers. The other party to the litigation was also a supplier, but one they worked with on a less frequent basis. In that case, even though the subpoena was highly objectionable, it asked for a wide array of documents that really should have been received from the parties to the case. Because we had such a close business relationship with the party issuing the subpoena, we took a slightly different stance. We wanted to be a good partner so that that business relationship kind of took precedent over the litigation concerns. So that is a big reason why it can be really important to evaluate these relationships and make sure you're not thinking about this just from a legal perspective, but also how does the business feel about this case and your involvement in it. Finally, in understanding the scope and context of subpoena, we would always recommend checking the docket and looking for issues of scheduling. Take a look for scheduling orders, case management orders, trial dates. All of this will really help you understand what the status of the case is. Is this the very beginning of the lawsuit and the parties haven't exchanged discovery between themselves, in which case they really shouldn't be looking to third parties at that stage of the case? Or are there key deadlines coming up? Expert disclosures are due, or summary judgments coming up, the close of fact discovery, where you know the issuing party is going to be pushing you to produce documents quickly because they're up against their own deadline. None of this will change the law on how you respond or any of that, but it might change how you frame your response and how you interact with the parties issuing the subpoena. Speaking of interacting with the party issuing the subpoena, objections is going to be a key part of that. The first important part of objecting to a subpoena is knowing the timeline. Under Rule 45, 45D specifically contemplates objecting to document requests, particularly with respect to burden. And it provides you a deadline of 14 days from the date of service or by the date of compliance, whichever one is earlier. So in that form we looked at where it specifies a date and time of compliance, if that date is before the 14 days from when you were served, that is the date that by which you have to serve objections. You do not want to miss this deadline. A lot of courts will find that you have then waived your objections if you do not provide them in time, and that is not a place that you want to be in. This can be a really simple process. A lot of counsel in our experience are amenable to granting extensions. You just want to be sure that you specifically ask for additional time to provide a written response and objections to their subpoena so that they don't think you're asking for an extension of time to provide documents in response, but you're very clear that this is an extension for objections. Even in situations where you might have missed your deadline, our typical recommendation would still be to reach out to issuing counsel and see if they would grant you an extension. With state court subpoenas, you're going to want to take a specific look at the state's rules. They tend to vary a little bit depending on what you might need to do. Specifically, the timelines might differ. Some states might not specifically contemplate objections in their rules. But as far as timeline goes, especially in Missouri, I know the deadline is 10 days instead of 14. So it's important that you're not calendaring a date for response that is based on the federal rules when they might not be applicable to the subpoena you're responding to. If you do miss a deadline as well, we would also recommend going back and taking another look at service and jurisdiction, making sure there's no argument that the subpoena is void and that you have in fact missed a deadline of a valid subpoena. Looking a little bit at what actual objections look like, A subpoena can be challenged for any number of reasons, but those objections will toll your obligations subject to a court order. Rule 45DB specifically says that if objections are made, then the party issuing the subpoena would be required to compel compliance with their requests, and that only with that order would you be forced to provide those documents, keeping in mind that you cannot provide significant expense to the non-party. You'll note these are a list of standard objections. A lot of these mirror what you would see in party discovery. The request might be vague or ambiguous. You don't understand what it's asking. It may be seeking privileged material. It could be overly broad, and it's not limited to the scope of the subject matter of the case. That said, there are some unique third-party objections that you should consider making. And this is because Rule 45D makes it a party or attorney's responsibility when they issue and serve a subpoena to take reasonable steps to avoid imposing undue burden or expense on a person subject to the subpoena. Because you're a third party to this case, you did not bring anyone into court, and you are not defending wrongful actions, potentially wrongful actions. You're in a different posture than the parties in this case, and you should be treated accordingly under the rules. So this means that the burden of producing documents is looked at a little differently than it would if you were the party. In a lot of jurisdictions in federal court, there is good case law supporting that parties must seek discovery from each other before they look to burden a third party. We get this a lot. A lot of subpoenas will request communications with plaintiffs or agreements with defendants, or other, knowledge and information that you would obtain from the parties to the case. We will often object to that information, saying that they should be getting that from the parties and not trying to get us to provide that information. A lot of times we'll get a response that they want to double check what the other party produced. That is likewise not an appropriate use of a third party subpoena in most contexts and would be considered duplicative or cumulative discovery. I will give one caution on objections you make that's a little different as a third party compared to party discovery, and that is on the basis of relevance. You've got to remember that you are an outsider to this litigation. The parties to the case are going to have a much deeper understanding of the discovery issues, the allegations, the defenses in the case, and you want to be careful to not object to something as relevant as seeking irrelevant information when that's really not the case. You're just going to want to be more cautious than you might otherwise. Our standard practice in providing objections is is to prepare a letter in response to the issuing party. Because you don't need to file anything, we find that a letter is a nice format to both explain the general problems we see with the subpoena, as well as going through each specific subpoena request and providing specific responses and objections to those requests. Additionally, if you receive a deposition subpoena, we find that it's a best practice to object to those topics to the extent they're seeking a corporate representative deposition and have provided topics for discovery, and just include that within the 14-day or date of compliance timeframe. It's not the same under the rules, which contemplate objections for document requests specifically, but we find that it's best practice to let the other party know that you object to their deposition topics and will not be providing someone to testify as they're currently written. Finally, one main objection that you might find, particularly for the healthcare companies, of which I know many of you are out there, is whether the subpoena is requesting protected health information, or PHI, in which case you'll need to consider your HIPAA obligations. And for that, I'm going to turn it over to Amanda.
All right, so as Sarah noted, I know that several of you attending this webinar are from healthcare companies or otherwise would be considered a covered entity or a business associate under HIPAA, and in which case this section would apply to you. So just as to kind of set the stage here, as a reminder, HIPAA only applies if you are a covered entity or a business associate and the subpoena is requesting protected health information. Some there's some misunderstandings out there sometimes where they think, oh, HIPAA just applies to all protected health information, but that's not the case. For example, if you're an employer and you have, for whatever reason, protected health information within your systems, HIPAA doesn't apply because you are an employer and not a covered entity. So just to recap, covered entities are typically healthcare providers, health plans, healthcare clearinghouses who are creating, maintaining, and transmitting electronic protected health information. And protected health information is information about someone's health, healthcare, the payment of healthcare services that could be reasonably used to identify an individual. So name, date of birth, social security numbers, things like that. So again, covered entities and business associates, if you are one, are only permitted to disclose protected health information under three main conditions. One is if it's for the purpose of health treatment, payment, or healthcare operation purposes. That's probably the most well-known purpose. If an individual whose PHI is at issue provides a HIPAA authorization to disclose, you can disclose. So keep in mind at any point during the subpoena process, if they're requesting PHI, if the individual gives their authorization, then you don't really need to worry about going through some of these extra steps that we'll talk about. But if neither of those are the case, then you need to meet a HIPAA exception. There is a few exceptions that cover the scope of a third-party subpoena that would permit the disclosure of PHI, but you have to meet certain conditions first before you move forward with disclosing the PHI, if at all. And these conditions vary based on who signs the subpoena. So in short, if the law requires you to disclose PHI, you can go ahead and disclose that information, but only the minimum necessary. And in this case, if it's a judge or a court order or under the scope of a grand jury subpoena, that the law considers those categorizations as the law. And so you don't need to provide notice to the individual. You don't need to go through some of these extraneous steps that we'll discuss. You can go ahead and disclose, but it must be the minimum necessary, PHI, to respond to the request. However, if it's signed by a lawyer, which often happens, you can't disclose the PHI unless you meet one of these three conditions. I'm going to skip to the bottom and talk about the last one first, which is providing notice to the individual. You have to demonstrate that you provided notice to any individual whose PHI is at issue, and you have to do this in a way that allows them the opportunity to object to the disclosure. The other two are you either have to receive satisfactory assurances that the patient was notified and offered the chance to object, or receive satisfactory assurances that a qualified protective order has been requested or is already secured. And we'll talk more about that, what that means. So what does satisfactory assurances mean? If you're providing notice to the individual, then receiving satisfactory assurances means that if you're the party receiving the third-party subpoena, then the party that requested the PHI, the one that issued the subpoena, must demonstrate, provide to you and the court that a good faith attempt was made to provide written notice to that individual. So a good faith attempt, for instance, might mean that if you can't necessarily locate the patient or individual whose PHI is at issue, a good faith attempt would be sending notice to the last documented address of record. The second condition is that the notice has to include enough information about the lawsuit at issue to allow the individual to raise an objection. So this would be things like what the lawsuit is about, the jurisdiction, which Sarah talked about earlier, how to respond to the subpoena and object, the timeline for objecting, things of that nature. And third, the time to raise an objection has either passed and no objection was filed, or all objections were filed and have been completely resolved by the court. So once those three conditions are satisfied, that equates to satisfactory assurances. The second, if you're seeking a qualified protective order, is that there has to be either a written statement and supporting documentation to demonstrate that the parties of the lawsuit have agreed to a qualified protective order and have presented it to the court, or the party seeking the PHI, the one issuing the subpoena, has requested a qualified protective order from the court. So there either has to be that agreement between the two parties, or the person issuing the subpoena has to provide that evidence that they already sought qualified protective order. And just to note, you only have to demonstrate that you presented and requested that qualified protective order to the court. It doesn't actually have to be fully resolved by the court yet for this to be considered satisfactory assurances. And just a reminder about what a qualified protective order is. That is a specific court order that prohibits the parties from using or disclosing PHI for any other purpose except for the litigation. And it requires either the return of PHI to the covered entity who provided the PHI or the business associate, or the destruction of PHI at the end of litigation. So if you've met those conditions that we just discussed, then you can proceed with the disclosure of PHI, assuming that the court is allowing the disclosure of PHI. So if the subpoena has been quashed, or a proper objection has been made, or the subpoena has been amended to not permit the disclosure of PHI, then you obviously wouldn't disclose the PHI. But this is assuming that the court has said, yes, we've met all the proper conditions and we think disclosure of PHI is necessary, then you can go ahead and disclose. However, you must still only disclose the minimum necessary PHI to respond, and you must disclose the PHI only in the manner requested by the subpoena. So for example, if the subpoena requests written records or electronic records, you should only disclose in that specific manner, rather than, for instance, a verbal disclosure. So you shouldn't be discussing PHI over the phone with parties to the lawsuit, for example. And as always, if you're a covered entity, you're required by law to log any disclosures of PHI, and this would be considered a disclosure. So you'll want to just make sure that this disclosure is documented in your PHI disclosure log.
So just touching on some of those, obligations that you have under HIPAA, from a practical perspective, from the litigation point of view, often what we will try and do is ask the parties if they actually need PHI, or can we de-identify the information that they're asking for to remove any of the protected health information. So for example, we have clients that will get requests for data showing all health claims. And what the parties are actually looking for is information about the drugs dispensed and the dates of service, or other information about how much the drugs cost, etc. They're not actually looking for information about the patients at issue here, in which case you can offer to redact out that information. If you're then redacting out any PHI and de-identifying that document or information, it's no longer considered PHI, and you don't have to follow all of these obligations under HIPAA. But that's something that would come up as you are negotiating with the other side and talking about what you're actually going to produce. We're not going to spend a ton of time talking about negotiating a third-party subpoena, but just It's important to know that this is one of the longest parts of the process, and usually takes the most time. So you've evaluated your obligations under HIPAA. You've sent an objection letter to the party issuing the subpoena. What happens next? In our experience, you usually get a request from the issuing party for a meet and confer. You might get that response immediately within 30 minutes, or you might get that response in 4 months. It just depends how much attention they are paying to third-party discovery in their case and what else they've got going on. What this process usually looks like is a series of back and forth phone calls or emails where the issuing party gets an opportunity to explain to you what is going on in the lawsuit, what the claims are, what their arguments are, and why discovery is needed from you as a third party to support their arguments, and why they can't get it from the parties, and that you're the only source of this information. This is also your opportunity to explain to that party why what they're looking for doesn't exist, would be very hard to find, would require an undue burden in order to produce. And there's a lot of back and forth in attempting to basically narrow the scope of the request to something feasible and reasonably accessible on your end as a third party. The hope is that by the end of those conversations, you've reached a point where you've agreed on a set of documents narrower than what's requested in the original subpoena that you're going to provide in response. And once you've come to that decision about what you're producing, these are some tips about actually providing those documents to the other side. First and foremost, before you make any document production, we would advise you to take a look at the protective order in the case. Hopefully they already have one in place, and it's just a matter of reviewing the language of that document. What you're going to want to look for is a couple main points. First, does it cover third parties? Every protective order is going to have provisions in it that protect party discovery and party productions. Many of them will also have explicit language that protects a third party's production if made in the case subject to this protective order. But you'll want to double check because it's not always explicit. You're also going to want to take a look at the designations contemplated by that protective order. What types of confidentiality designations does it offer? Does it just protect information as confidential? Does it have a highly confidential or attorney's eyes only designation? And in addition to looking at what types of information would be considered under each level of designation, you'll want to take a look at who is entitled to review each type of document. So just because something is labeled attorney's eyes only, does that mean only outside counsel? Does that include in-house attorneys as well? Does it actually provide for additional business folks inside internal business folks at one of the parties to view your confidential documents or attorney's eyes only documents? That's something that we've found requires really close attention, in particular because most protective orders, including in highly confidential or outside counsel eyes only designations, have broad provisions for permitting consultants and experts to review your documents. This might not be an issue for you, but we have had clients that are producing highly sensitive materials, potentially in the context to competitors or entities that they regularly conduct business with, that they wouldn't want to see outside of this context. And likewise, those companies are engaging experts and consultants that are in highly specialized areas of expertise. And we've had instances where those experts in the litigation context might get access to very proprietary pricing or contract information. And then they can turn around and use that information in representing our clients' business partners in contract disputes against them. Or not disputes, but just negotiating a contract. So you'll want to be very careful about who can look at these documents, and do you have any particularized concerns about who's going to see your information? If the way the protective order is worded in the case doesn't cover your unique concerns, don't be afraid to negotiate additional protections. In that instance I was just describing, where they had experts turn around and use their information against them, our client has now gotten into the practice of negotiating supplemental protective orders to make sure that any experts that are going to see this information are not working in negotiating contracts against our client or working in that space. So be sure to look at the protective order, consider whether you need something supplemental, or if there's no protective order at all and you're producing documents, you might want to consider asking the parties to put one in place. Again, to what Amanda was talking about earlier, if PHI is going to be produced, you may need to consider whether the protective order is a qualified protective order. She's going to talk in a little bit more detail about what that might look like and what to look for.
All right, so as I was talking about earlier and mentioned, a qualified protective order under HIPAA is only applicable, again, if a subpoena requests PHI and you're a covered entity or a business associate. So again, if you don't meet these 3 requirements, you don't need to worry about this. But again, if it does, you'll want to review the protective order to make sure it is a HIPAA qualified protective order. As a reminder, this protective order prohibits the parties from using or disclosing PHI other than the purpose of the litigation, and would require the return of PHI to the covered entity or its destruction once litigation concludes. One thing to note is that a lot of states and jurisdictions do have their own preferred standard court order form that they use for HIPAA qualified protective orders. So if PHI is an issue, you'll want to be sure to check with your specific jurisdiction and rules to see if they do have a standard form. I am in Chicago, so I pulled this one from the Circuit Court of Cook County, just to kind of show you what this may look like. This is their standard template. You can modify this one. This is just a sample that they use, but it gives you an idea of what this looks like. And when you're reviewing these protective orders, you'll see pretty quickly whether it's HIPAA qualified or not. It's usually going to refer to HIPAA, as you see in term 3 here. And it's referencing protected health information. It's referencing the CFR at issue where HIPAA is located. So it's going to be pretty obvious when you're looking at the protective order, whether it's HIPAA qualified or not. You're going to want to look for those restrictions on the use of PHI and the disclosure of PHI and the provisions that require the return or destruction of PHI.
So talking a little more generally about producing documents, Rule 45E1 is specific that you must produce documents as they are kept in the ordinary course of business, or you have an obligation to organize and label them to correspond to the categories in the demand. As you can imagine, our typical practice is to produce documents as they're stored in the ordinary course of business, as that tends to be a little easier than organizing the documents to address the specific requests from the issuing counsel. Just as a best practice, I'm sure a lot of you are familiar with producing documents in litigation and providing it with a Bates label or some type of label that will tell you what was produced. We just find that it's a best practice to make sure you're tracking these documents and you are aware of what was produced in response to a subpoena. Likewise, that same mechanism will allow you to attach a confidentiality designation, again, having considered the protective order and what the different levels of confidentiality are. That way you can address you can label your documents according to the protective order's language. As I mentioned earlier, you may need to redact or de-identify a document to remove PHI, or you may need to redact a document to protect confidential information that is not relevant to the case. That is something else you'll want to consider doing before making the actual production. Now, I would just make sure that you use the appropriate redacting tools if you're doing this in-house to make sure that it's something that will actually scrub the data and those redactions cannot be removed, even though that would be unethical for those attorneys to do that once you've produced redacted documents, but just something to make sure. Finally, I wanted to address the opportunities for fee shifting. This is not something that's very common and would be worth looking at the rules in the jurisdiction where you're in and where this is taking place. But we have had success for clients in asking for the party requesting documents to pay for certain costs or expenses associated with providing the documents they're asking for. This tends to work best in circumstances where there is a very specific hard cost associated with collecting or producing the documents they're requesting. For example, we've had clients who have been asked to provide data, and that data might be archived in databases that are hard to access, in which case we've had to engage a vendor who can locate that information, pull it, and put it in a format that is producible to the other side. That vendor is going to be able to give us an estimate and a hard cost associated for us of doing that work. And we can turn around and take that estimate or invoice, ask the other party if they would be willing to pay for the information. Because we're willing to provide the documents, but we might not be willing to pay $10,000 to get it for them. And that would probably be considered an undue burden and expense on a third party. So those are just opportunities to think about and might be worth asking for. Again, our experience is that with hard costs, it's usually the easiest way to get someone to pay for something. So most of what we've talked about today has been looking at responding to document subpoenas. And that's because in our experience, that tends to be the bulk of requests and types of subpoenas that our clients are receiving. That said, documents sometimes aren't enough. So I'd like to talk briefly about what you might consider if you've received a deposition subpoena. First, a couple reminders would be if that deposition subpoena was requesting a corporation or a corporate representative deposition, it would have been accompanied by topics. And our recommendation would be that you have objected to those topics when you are sending your objection letter at the outset of this engagement. We would also recommend, or another reminder is that the place of compliance and the 100-mile rule would apply here. So anyone that's required to sit for a deposition could only be required to do so within 100 miles of where that person resides, is employed, or regularly transacts business. A couple things to consider if you do receive a deposition subpoena is engaging with the issuing party about whether they actually need someone to testify in a deposition. A lot of times what they really need is a records custodian declaration, which is something that will authenticate the records that you're providing so they don't have to call your witness at trial to testify that those are business records and lay the proper foundation to get them into court. Sometimes they do need some expanded testimony that is not provided for in the documents you provided. In that case, it might be worth discussing whether a slightly expanded declaration, if there are key statements that you can put in writing and have someone sign that may be provided in lieu of having someone sit for a deposition. This is a strategy consideration that you're going to want to think through. Keep in mind that those statements would be in writing. You may provide it to one side and the other party then asks for a deposition, or you might get called at trial and they've got statements in writing that they want you to testify about. But you've got to weigh that with the cost and expense of maybe having one of your employees sit for a deposition instead. So other proposals you might want to consider would be talking to the other party about whether you could limit the time for a deposition. As a third party, maybe they only need 2 hours worth of testimony from your witness, and you can agree to limit the deposition in that time frame. Another option would be to request that they provide you with the exhibits they're going to use in advance. We've definitely had success with this in the past, especially where, as a third party, you don't have access to the types of documents that you would as a party to this case. So you don't have an opportunity to look through and have an idea of all the documents that have been exchanged. And if the issuing party wants meaningful testimony from your witness about the documents that they're going to ask about, it may be in their best interest to provide those ahead of time so that whoever you're proposing can provide actual testimony on those documents having been prepared in advance. And finally, sometimes you just can't come to an agreement, whether it's about documents or depositions, and you have to go to motion practice. We would recommend engaging outside counsel if you get to motions practice and you haven't already had someone helping you in responding to these subpoenas. There are 3 key motions that might pop up in responding to a third-party subpoena. The first is a motion to compel. This would be something filed by the issuing party seeking to compel the non-party to provide documents or sit for a deposition or appear and provide testimony at a hearing when you have refused to do so. A motion to quash is a motion that attempts to completely void the subpoena and prevent its enforcement in its entirety. A motion to quash is specifically contemplated in Rule 45, which provides 2 different standards for a court to consider. It has options when quashing a subpoena is required, like when it fails to provide reasonable time to comply, extends beyond the geographical limits specified in the rule, or requires disclosure of privilege protected information. Or finally, and probably the biggest hook, is when it subjects a person to undue burden. A court may quash a subpoena if it were to require disclosing trade secrets or an expert opinion. So you'd have to look at the specific rules about what grounds you're seeking to quash that subpoena. And finally, a motion for protective order is very similar to a motion to quash, but it doesn't necessarily request that the subpoena is voided in its entirety. Rather, it's under the Rule 26 standard that protects a party from annoyance, embarrassment, oppression, or undue burden or expense, and can often be used to more narrowly tailor what you find about the subpoena to be objectionable, and maybe carving out requests that you shouldn't have to respond to while providing a response to other pieces of it. A reminder again is that these motions would be filed in the district court where compliance is required. So for example, if you're, we had a case where the case was pending in the District Court of New Jersey, but the party wanted to depose witnesses that were located in Pennsylvania and in Tennessee. When we filed motions to quash those subpoenas, we didn't do that in the District Court of New Jersey, but rather had to find local counsel and file those motions in the District Court in Pennsylvania, as well as one in Tennessee. So it's always important to keep that in mind, because you will want to plan ahead if you're going to need local counsel, know what your timing looks like, because you have to take a couple extra steps. That those motions may be transferred back to the issuing court, the court where the case is pending, under the standard that we talked about at the beginning of this presentation. But sometimes courts will hold on to those motions as well. As we're running out of time, I just want to note that most parties don't want to go through the time or expense of motion practice. I wanted to just touch on it briefly because it's very important to understand what might be required so that you can be prepared, because it is always a possibility and it is often a threat by the issuing party. And with that, that is the end of the presentation that we had on third-party subpoenas today. I'm going to take a look and see if we've got, I see we've had some questions come in. Let's see, we had a question about who typically drafts and signs the objection letter and negotiates on a third-party subpoena, whether that's a litigator or a non-litigator. In my experience, it is often a litigator. Particularly if companies engage outside counsel to assist them. This can be an adversary proceeding, and so sometimes it helps to kind of have a litigator aimed and understand the litigation at issue and how you're going to play a role in that, be involved in case of motions, etc. That said, I know a lot of companies might handle these in-house with not necessarily litigators as counsel. It might be a small subpoena asking a very narrow set of documents that is easy to provide, and you don't really need a litigator's involvement. So it might depend on what the subpoena actually is in the context as to who you need to be involved. I know we received a couple other questions, but we are out of time, so we will make sure that any of those get addressed by email after this presentation. Thank you so much for joining us today. We hope the information was helpful to you and your organization. Quick reminder, this program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. This concludes our webinar. Thank you so much for joining us today.